Macedonian prosecutors and law enforcement officers want to obtain bank records or telephone records or interview a witness here in the United States at its simplest terms. And we want to cooperate and help and make that happen. And we hope that, and we take it on good faith, that the investigation in Macedonia is free from, let's say, external influences, free from political influence, free from other types of influences that might temper or shade the integrity of the investigation. And so when I receive a request from Macedonia, for any country for that matter, not just Macedonia, but I have to feel that this request is a legitimate law enforcement related request. Not only if it's a request for information, but let's say it's a request for extradition. I have to feel confident, the Department of Justice, and then ultimately on an extradition, the Secretary of State of the United States has to feel comfortable that the person that is being sought in Macedonia will receive a fair trial, that the charges are not politically motivated, or they're not as a result of corruption. And it's not just Macedonia, but it's other countries around the world. We do the same process in review and evaluation. So I hear what Judge Stearns and Tom Peebles have been talking about, the reform of law in Macedonia, and I'm heartened by that, and I hope that your country will continue to evolve. Our country is evolving too. I mean, obviously we have missteps. We occasionally have problems in this country. We're not perfect, no one is. But I hope that as we continue to work together, that our cooperation will go to a higher level, where you will feel comfortable, and the authorities in Macedonia will feel comfortable in talking to us about the most sensitive of investigations, and we will do the same thing likewise, and that we will be able to deal with the types of crime that are important to both of us, not just the crime at the local level, murders and robberies and sexual assaults and things like that, but transnational crimes that affect all of us universally throughout the world.
Firms, and I think my perspective will be a bit more positive, I might say. I know that Macedonia has taken reform very seriously in the last few years, and as what we measured in our report, Macedonia has received the top reformer status several times already, and they've done a lot in areas, more administrative reforms, such as how to start a business, where now in Macedonia it's one of the fastest places, at least in the region, to start a company. In the judicial area, where our indicators touch upon that, in enforcing contracts, Macedonia ranks 65th out of 183 countries in the world. So it's not that bad, and I have to say that what we look at is a claim between two companies, and we look at the same type of claim in every country, and we have certain assumptions related to that, so that we're looking at, in Macedonia, the claim would be for about $8,000 US, so not a very big claim. And we ask lawyers in the country to tell us how long it would take for that claim to go through the court and how much it would cost. And in Macedonia, it would take about a year for that claim to be fully tried and enforced, and it costs about 1/3 of the claim. So it's 1 year seems like a long time, but I think in comparison with many other countries, it's not that long, because time is money for firms, so 1 year without having your claim, before being able to enforce your claim is a long time, but at the same time, justice needs some time to actually have a fair trial. So what we've seen in Macedonia is there's a lot of room to improve on this, and one of the main complaints that we hear from people on the ground is that for every claim that is brought to the court has to review it before it serves the defendant, and that's something that sometimes takes a very long time. And one area that we've seen other countries improve on this is through e-filing procedures and electronic case management in the court, which sort of takes away some of this lengthy procedures of serving the defendant the complaints. And so we hope that our report brings to Macedonia, and I know the Macedonian government is already very aware of it, is sort of a benchmark of what other countries are doing in the region, and the best practices which keep changing. I mean, 10 years ago, electronic systems were probably not as prevalent as they are today. But today we see a lot of countries implementing these systems, and from what I hear, we have a team right now in Skopje looking into this, that there is some reform in this area, and the courts are becoming more computerized, and I think this will greatly reduce the time that it takes to enforce contracts. in Skopje. And one other indicator that we look at is how to close a business. So when a firm goes bankrupt, how long it takes for that firm to actually be able to process its bankruptcy, its insolvency. And there, Macedonia ranks at 116, so quite low still in the ranks. And we find that these type of reforms are the most difficult to implement, because one thing is to pass a law, and you can pass a very good law, and I think Macedonia did pass a new bankruptcy law recently, but to actually implement it, to educate the judges and everyone how to comply with the law is still a big challenge.
Well, thank you. I think that has given us certainly a menu of areas that are in need of improvement within the legal system and the judiciary system. I'd like now to turn and ask the panel members to discuss, and some of them already touched on it a little bit, but maybe dig a little deeper into how those issues and obstacles can be addressed and what already is being done, and sort of nuggets of positive progress that they see going on in those areas. And I'd ask to start with Judge Stearns.
Okay, now I get to bring the good news. And these aren't unique observations of mine. Judges in Macedonia who are reform-minded recognize them. They're recognized in the law schools and in some levels of the government. An entirely new code of criminal procedure has been adopted as of January. The program of implementation is 2 years, which I think is staggeringly quick. The code in its English language version runs 218 pages. So I explained to the commission that was drafting it, it would take 2 years just to read it. You know, much less implement it. It's far more complicated than I think it needed to be, but it's certainly well-intended and contains some very interesting ideas for reform. You have to understand that reforms don't just happen overnight. They have to be culturally instilled in those who, in a judicial system, are responsible actors. As I tried to explain in Macedonia, in the United States, the great judicial reforms, that is the system that we are now so proud of today, really came about as a result of the Warren Court in the 1960s. This is a relatively recent innovation. You know, I lived through most of that period. It took 20 years to internalize those reforms in the United States. Judges were the quickest, perhaps, to accept the changes, but not immediately. It then happened, after that, the police followed. The police actually liked a lot of the new reforms that were introduced because their cases were easier, safer, and less vulnerable to a legal attack. The most resistant were the prosecutors and the lawyers, because we tend to be the most tradition-minded, you know, of all of the players in the system. So I think it's very ambitious to think that for 2 years you're going to see the changes. But many of the changes I've advocated and others have advocated are now adopted in the way at least the code would like to restructure practice in Macedonia. Just a couple of examples. Equality of arms is introduced. Over time, not necessarily in this code, but in other legislation, a new office of the Prosecutor General basically has been created to try to give more independence and identity to the prosecutors as a group. The steps towards abolishing the distinction between the investigating judge and the judge have been taken. That is, the role of the investigating judge is slowly being abolished in Macedonia. The judge is being moved more to a neutral role. In criminal cases, defense lawyers are now given the right to call their own expert witnesses independent of those produced by the state, and some right of access, as they have in Europe and the United States, to the file of investigation in the case in terms of preparing their defense. They're also now permitted to hire their own investigators and conduct, at least the lawyer for the defendant can, an investigation on his own. One change I suggested, which has been adopted, is Rule 11. Rule 11 is shorthand for plea bargaining. Very controversial in Macedonia, but the almost verbatim Rule 11 of our Code of Criminal Procedure has been adopted in Macedonia. I think this will do an enormous step towards expediting the resolution of criminal cases, as it does in the U.S. The other reform, which I've been a strong exponent of, and it has been adopted, but it's still not really fully implemented, is the reform of the pretrial detention system. On the criminal justice side in Macedonia, the practice was to lock up anybody who was arrested and hold them until the trial, usually and very often for longer than they would ever conceivably serve if convicted and sentenced. It was just more convenient for the judge and the police and so on to put the defendant in jail, keep them there until the case was resolved. Under the new code, Macedonia has adopted basically a copy of the United States Bail Reform Act of 1984, which now gives the judges options of putting people out on surety. Bail was always traditional in Macedonia, but now with guarantees, even electronic monitoring, the defendant can afford it, with guardians, with curfews, with reporting requirements, alternatives to putting someone in detention waiting for disposition of their case. Some steps have been taken toward trying to make the judiciary more self-governing. State Judicial Council has been created to try to give the judges more independence and more say over the day-to-day activity of the judiciary. Although, again, every time you think you've taken a step forward, when I was there, a fight broke out between the Minister of Justice and the Chief Justice of the Judicial Council as to which of them had the power to punish judges for acting too slowly on cases. Well, the Minister of Justice has no business in this area of judicial discipline, but that's not the way the minister saw it, and I suspect he hasn't changed his mind since I was there in 2009. On a more technical side, I've seen great improvements in the IT systems. I mean, Macedonia is not a rich country. It's not easy to basically put a court on an electronic system, but some courts have made astonishingly good progress. And even in some cases, in some courts, now you can go on the web and access judicial calendars, judicial decisions, which is something the public could not do before. So the steps, conceptually, I think are there. I think Macedonia's got all the laws it needs. There'll always be a few that we'll think of that may improve things, right? The laws are there. Now it's a question of implementing them, the will to execute them, and then to internalize them. And that's what takes the longest. Like, that's a generational issue. Put judges comfortable with their role, prosecutors with theirs, and everybody else in the system with the appropriate role they should perform. So there is good news. It's just going to be a while.
All of you who are Macedonia watchers, whether you be whatever continent you may find yourselves on, watch very closely what happens over the course of the next 2 years. As Judge Stearns said, this new, very, very complex code is supposed to be fully implemented and put into use by the end of the year 2012. And certainly all the people I've talked to in and from Macedonia are of the same view that Judge Stearns indicated. It's just way, way too soon. But each of the major actors in the criminal justice process will have a very different role. Marcus and Judge Stearns referred to the role of the judge, who will no longer be an investigator, will be the more neutral arbiter of fact and apply the law closer to the model that we have in the U.S. Big changes are on the works for both the prosecutors and the defense attorneys. As has been referred to, this new code, like many of the new codes in the region, adopt some of what we call in the U.S. our adversarial processes, where each side is charged with basically developing a case and presenting to this neutral arbiter judge the strongest case possible, the prosecutor for the state and for the imposition of criminal sanction, the defense bar for his or her client with minimal or no sentence, no criminal sanction imposed. And the idea, a little bit different than what currently exists throughout most of Southeast Europe, is that, you know, between these two strong presentations of the strongest side for each, the truth will ultimately be, will come to light, sorted out through, again, this neutral, neutral arbiter that is the judge. The prosecutors and the police will have to work much more closely together than they have in the past. And this also will be a huge, huge change, but in terms of organized crime and corruption, the two issues that I referred to initially, we found in the United States that nothing beats good police prosecutor cooperation to build those big cases against organized crime figures, corrupt public officials.